Sir, please state your name.
My name is Brian Cutler.
And how are you employed?
I'm a professor at Ontario Tech University.
Mr. Cutler, do you hold any titles to your name?
I have a master's degree and a doctorate degree.
And can you tell the jury about your educational background?
Yes, I have a bachelor's from the University of Rochester in upstate New York, a master's from the State University of New York at Geneseo, that's Geneseo, and a doctorate degree in psychology from the University of Wisconsin at Madison.
And Doctor, I believe you just testified that you are also a professor at the current time, is that right?
That's correct.
And where is that at?
It is Ontario Tech University in the Toronto area.
And what classes do you teach as a professor?
I teach a wide variety of courses, most recently undergraduate courses for a forensic psychology program, and those courses include the psychology of eyewitness testimony, and I teach a course on expert testimony. I also teach graduate courses in social psychology and professional development. I've taught a wide variety of courses over 30 years or so.
And I guess your answer may have just answered this, but how long have you been a professor at Ontario Tech?
I've been a professor at Ontario Tech since 2008, but I was at two other universities before that.
So as you indicated, in some you've been teaching for approximately 30 years, is that correct?
That's correct.
Can you tell the jury about your employment prior to being a professor at Ontario Tech?
Yes, I was a assistant, associate, and full professor and university administrator at Florida International University in Miami, and I was that was between 1987 and 2002. And between 2002 and 2008, I was professor and chair of the Department of Psychology at the University of North Carolina at Charlotte. And then since 2008, I've been with my current university, Ontario Tech University.
Do you have any areas of specialty in your field?
I do. My specialties are social psychology and forensic psychology.
Have you written any books or articles in the fields of social psychology or forensic psychology?
I have.
And what are the general topics of your scholarly work?
Most of my writing of books and articles has been in the area of forensic psychology, that is the application of psychology to the legal system. The topics on which I've written are the psychology of eyewitness memory, and more recently, the psychology of interrogations and confessions. There have been other research topics in forensic psychology and in general social psychology as well.
Doctor, do you have a current resume or curriculum vitae?
I do.
May I approach your honor?
You may.
Dr. Cutler, I'm going to hand you what I have previously marked as Defense Exhibit H2. I would ask you to take a look at that and tell me if you recognize that document.
I do.
And what do you recognize that document as?
This is my curriculum vitae.
And generally speaking, does your curriculum vitae contain a list of your academic and professional achievements that you've had throughout your career?
Yes, it does.
Do you believe the information contained in your CV is accurate?
I do.
Your Honor, at this time I would move to admit Dr. Cutler's CV.
Exhibit number.
Exhibit H2, Your Honor.
Any objection?
No, Your Honor.
Exhibit H2 is received.
Now, Dr. Cutler, I want to review just a couple of things that's contained in your resume to, again, give the jury an idea of your expertise. Back in 2008, you were the editor of the Encyclopedia of Psychology and Law, volumes 1 and 2. Is that correct?
Yes, that's correct.
In 2014, you were the editor of the American Psychological Association, or the APA's Handbook on Forensic Psychology. Is that correct?
That's correct as well.
And more specifically relevant to this case, have you authored any articles or books on the topics of interrogations and false confessions?
I have.
Are there any treatises or publications that you would rely on as well in your field of work?
There are.
And generally speaking, what would those be?
Generally speaking, I rely on the forensic and social psychological literature and research that I've followed for many years. There's bodies of research on such topics as social influence and persuasion, and then more specifically on interrogations and false confessions. There are also some particularly influential sources. In 2010, my professional association, the American Psychology Law Society, which is Division 41 of the American Psychological Association, endorsed a scientific review paper that was developed over the course of several years. It was the authors were Saul Kassin, Kassin, and colleagues. It was a very comprehensive article. It was published in our top peer-reviewed journal, and it reviews a great deal of the relevant research to date. So I rely on that source. There's also a very comprehensive book by a scholar named Richard Leo, who authored a book, I believe it was in 2008, on interrogation and the American justice system. So those are two sources among much other literature on which I rely. I've also followed pretty carefully the literature on training in interrogation, such as a book by Inbau, that's INBAU and colleagues. It's published in 2013, I believe. That is essentially a manual for interrogators. So I've followed and relied on that literature as well.
Have you been involved in any empirical research, laboratories, findings, things like that you're personally involved in?
I have.
And can you tell the jury about that?
Sure. In 2014, a colleague and I were awarded a research grant from the Social Science and Research Council of Canada, one of our research funding agencies. And the purpose of that grant was to develop a reliable and valid assessment tool for assessing coercion in videotaped interrogations of suspects and witnesses. The idea is that with increasing frequency, interrogations are videotaped. And our grant was to develop a method of analyzing coercion that can take place in these videotaped interrogations. So we've been working on that project pretty steadily since 2014.
Your Honor, at this time I'd ask the court to recognize Dr. Brian Cutler as an expert in the fields of social psychology and forensic psychology.
Any objection?
No, Your Honor.
Dr. Cutler will be recognized by the court as an expert in the field of social psychology and forensic psychology.
Now, Dr. Cutler, in addition to being a professor at Ontario Tech, you're also the president of a company called Coral Coastal Group, LLC. Is that correct?
Coral Coast Group, INC. It's INC.
Okay, that's mostly right.
Yes, mostly
Okay.
right.
Can you tell the jury what Coral Coast Group is?
Yes, it's a company a corporation that I formed in 2017, basically to facilitate my consulting and expert testimony work, but also to facilitate my training of graduate students in this area. One of my major responsibilities has been and is training graduate students, so it's a way of incorporating them into my work and giving them important practical experience as part of their training.
And so would it be accurate to say that Coral Coast Group is essentially the medium for which you provide consultation services?
That would be accurate, yes.
Okay. How many times have you provided sworn testimony in a court of law?
I've testified in court probably around 75 times. I don't have an exact number.
How often have those cases go to trial? Do you recall?
I've testified before juries about 55 times.
Specifically on the topic of interrogation and false confessions, how many times have you provided testimony to a court of law?
Objection relevance, we've already stipulated.
Overrule. Go ahead and respond.
It would be a smaller number of cases. I believe I've testified on this topic 11 times.
Do you recall when the last time you provided testimony regarding false confessions in a U.S. court of law would have been?
The last time I provided testimony in court on this topic would have been in August of 2019.
Have you ever testified for the prosecution in a criminal case on the topic of interrogations and false confessions?
I have not.
Is there a reason why that is?
I've not been contacted by prosecutors in cases of this type. It is normally defense lawyers in criminal cases, or and I'm sometimes involved in civil cases where I'm contacted typically by plaintiffs' lawyers, but I've not yet been contacted by a prosecuting attorney in this type of case.
Would it make sense to you that a prosecutor would be seeking your knowledge about whether or not a confession was coerced?
Objection, speculation, or foundation.
Sustained.
Have you worked with prosecutors before, Doctor?
I have.
In what ways?
I also offer consultation and expert testimony on the psychology of eyewitness memory. I have been contacted by prosecutors on 2 occasions to serve as consultant in cases involving that topic. I've also, in my scholarly work of editing a journal and editing books, I have worked with a small number of prosecuting attorneys to publish their work in our sources.
You are listed as a year 2020 speaker for the International Association of Interviewers. Is some information I found, is that correct?
That's correct.
Can you tell the jury what the International Association of Interviewers is?
Yes, it's an association that is dedicated to training interviews and best practices in interviewing and to set up a forum where they can network with one another and learn from one another.
Have you also testified in police officer disciplinary proceedings?
On one occasion, yes.
And what was that about?
That was a case where a Vancouver police officer was charged with various disciplinary infractions following an investigation by a special unit of the RCMP. In that case, the Vancouver police officer was subjected to rather coercive interrogation procedures, and I testified as an expert on interrogation in that case.
Doctor, do you recall when it was the defense team for Kelsie Thomas first reached out to you in this case?
I believe it would have been June 2019.
And initially, my office contracted with your company to perform a case review of the final interrogation of Kelsie Thomas. Is that your understanding?
That's correct.
And generally speaking, what would a case review entail? What services would you perform?
In a case like this, we would, where there is a videotaped interrogation, we would carefully review the recorded interrogation and other relevant material provided to us, conduct an evaluation of that interrogation using a specific coding system that we've developed over time, produce a report from that evaluation, and share it with the defense lawyers who contracted with us.
And specifically in this case, for performing your case review, you agreed to a flat rate of $1,500, is that correct?
That's correct.
Now with that $1,500 fee, was the defendant, Kelsie Thomas, guaranteed any sort of favorable opinion from you?
No, certainly not a favorable opinion, but our objective was to provide an objective evaluation of the interrogation.
In all the cases that you review, do you always find that the cases are coercive?
We do not.
And how often would you estimate do your case reviews actually result in you providing testimony in court as you are here today?
Objection, proper bolstering.
Sustained.
In the context of your work for Coral Coast Group, how many times have you provided testimony in court?
In interrogations and confession cases, I've provided testimony in 11 times, 10 different cases.
Now, I've used that term a couple of times, Dr. Cutler. Can you tell the jury what an interrogation is?
An interrogation is a procedure conducted by typically police investigators as a means of trying to obtain information to solve a crime.
Have you been through interrogation training yourself?
I have.
Can you tell the jury about that?
The most prominent organization for training interrogators in the United States and elsewhere around the world is called Reed & Associates. It's a company out of Chicago. They've been developing and training interrogation methods since the 1950s and have trained more interrogators than any other organization. And I've been through their training and have followed closely their manuals, some other materials that they put out. I've also studied other methods of interrogation as well. But that is the organization where I went through training.
What is the goal of an interrogation?
The goal of an interrogation, broadly speaking, is to try to solve a crime. The person being interrogated, usually a suspect to the crime, is believed to have information that's relevant to solving the crime. So through the process of interrogation, the investigator tries to get information from the suspect to help solve the crime.
Doctor, are you familiar with the phrase guilt presumptive interrogation?
Yes.
And what is that? What does that term mean, and how are you familiar with it?
Sure. Guilt presumptive interrogation means that for the purpose of interrogation, the investigator assumes the suspect to be guilty. Now, this is part of the training that's part of what we call the Reed technique, or as I mentioned earlier, the technique that Reed & Associates trains. And the way it works is investigators develop a suspect through other means. It could be through interviewing the suspect, and the investigator thinks the suspect is being deceptive or otherwise withholding the truth, or perhaps develops a suspect through other evidence, and then decides to interrogate the suspect. So at that stage, when the investigator decides to interrogate the suspect, the investigator assumes, for the purpose of the interrogation, that the suspect is guilty. Well, why do that? The idea, the goal is to get information from the suspect that helps solve the crime. The process involves using various tactics or techniques to try to get the suspect to confess to the crime, because once the suspect confesses to the crime, then it's easier to get the suspect to provide information such as how the crime was committed or other details that the investigator can then go out and try to corroborate with other evidence and ultimately solve the crime. So guilt presumptive interrogation means for the exercise of interrogation, the investigator assumes the suspect to be guilty.
In your experience, doctor, is guilt presumptive interrogation a common practice?
Yes.
Are you familiar with the term false confession?
Yes.
And can you define what false confession means to the jury?
Sure. A false confession is one in which an innocent suspect falsely confesses to the crime of which he or she is accused.
Are false confessions an actual thing?
It is a thing. It may seem counterintuitive, but there are various ways that innocent people falsely confess. The most common way is that in the course of coercive or highly persuasive interrogation, the suspect ends up basically succumbing to the pressure and confessing to the crime. We know that false confessions occur for various reasons. There is a body of research on known cases of wrongful conviction. There are organizations that keep data on wrongful convictions, and in those cases, false confessions come up regularly. For example, the National Registry of Exonerations, which is housed at the University of Michigan, has to date counted over 2,500 cases of known wrongful conviction, and about 15% of those involve false admissions or false confessions. The Innocence Project out of New York City logs exonerations that are DNA-based. So the DNA evidence proved that the persons convicted did not commit the crimes. And in those cases, about 25 to 30% of the cases involve people falsely confessing to the crime. So we know from actual cases that there are instances of false confessions. And we also know, because there's a growing body of laboratory research in psychology departments on false confessions, where we're able to get people to falsely confess to transgressions in our laboratories. So from various sources, we know that false confessions sometimes occur.
Dr. Cutler, in this case, in order to perform your case review, what materials were provided to you?
We were provided with recorded interrogations with Ms. Thomas and various other police reports.
Now, the jury's heard generally how you do your work, Dr. Cutler. Specifically in this case, once you receive the materials that my office sent to you, can you walk the jury through the process you use specifically in this case in coming to any opinions that you have?
Yes, I began by assigning the task to my lead doctoral student in this area, whose name is Jeff Kaplan. He's been working on the research grant that I described since 2014, and has really played a lead role in developing our method of assessing interrogations. So he conducted the coding analysis of the interrogation. We had another graduate student, another doctoral student whose name is Danielle Brumschick, and she was involved in this as well. She was in training, so she also reviewed the interrogation and reviewed a draft of the report that we produced and provided input. I also reviewed the interrogation and the draft report that Mr. Kaplan had produced, made some suggestions for changes along the way, and ultimately approved the report. We then met with defense counsel by teleconferencing and explained our findings with defense counsel.
Now, Dr. Cutler, is it the case that your graduate students completed this report and you just reviewed that, or how does all that work?
Well, they drafted it, and I reviewed drafts of it along the way, suggested changes, and ultimately I'm the one responsible for it. And as I mentioned, I also reviewed the interrogation, but the initial drafting of the report was done by my doctoral student, Mr. Kaplan.
Do you recall how many times, for purposes of your testimony, you would have reviewed the materials yourself?
I have reviewed the video probably at least 3 times. Parts of it likely more. And I've reviewed the written materials 2 or 3 times also. And
would that be your common practice when you're preparing to provide testimony, that your graduate students would analyze all this information, prepare a report? All of this would be in the normal course of how you typically do this, is that right?
Yes.
Now, Dr. Cutler, as an expert in the field of forensic psychology, were you able to reach an opinion regarding the interrogation of Kelsie Thomas?
Yes.
And just so the jury is clear, Dr. Cutler, you are not expressing an opinion about the accuracy of the confession. Is that true?
That's correct.
In other words, you don't know if Kelsie Thomas was telling the truth or not during the interrogation, and that's not what you're here to testify about, is it?
That's correct. I don't know whether she's telling the truth or not, and it's not my role to comment on that.
Now, did you, in doing the analysis, did your team produce any paperwork as a result of that?
Yes, we did.
And what was that?
We produced a report which contains a series of tables that are basically lists, interrogation tactics, and accounts of those tactics. We also included examples of the interrogation tactics used. So it's just a series of tables describing in quantitative and qualitative terms what occurred during this interrogation.
Okay. And what I'd like to do, Doctor, is walk you through your report with the jury, but before we do that, I asked you if you rendered an opinion without asking you what that opinion was. So were you able to come to an opinion about the interrogation that was conducted on Kelsie Thomas?
Yes.
And what is your opinion?
The opinion that this was a highly coercive interrogation, the kind of which that could lead both to a guilty person providing a true confession or an innocent person providing a false confession.
And now, doctor, as I said, I want to walk you through the contents of your report. Do you have that available with you?
I do.
And if you need to refresh your recollection, I'd prefer you just don't read directly from it. Is that all right?
I'm sorry that I don't read directly.
Well, your report, ultimately your testimony is what it is, but if you need to refresh your recollection, you have your report with you, correct?
Yes.
Okay. Now, your report is broken up into tables, correct?
Yes.
Table 1 indicates the duration of the part that you reviewed was 3 hours and 3 minutes, is that correct?
That's correct.
Now, sort of off the table, were you aware that Kelsie Thomas was questioned for longer than 3 hours and 3 minutes on that particular day?
Yes.
Did you make any observations? Let me strike that. Would it be accurate to say that your observations as contained in your report only go to the last 3 hours that I asked you to review?
That's correct.
So in other words, you observed and were aware of all of the interviews of Kelsie Thomas, but your report only speaks to the last 3 hours. Is that true?
I don't know if I observed all of the interviews with Ms. Thomas. I did observe one other interview, but regardless, the report only refers to that one interview.
Now, as far as the techniques and tactics that you observed that we're about to talk about, did you observe those same tactics utilized against Kelsie Thomas in the other portions that you were able to review that are not subject to this report?
Yes.
Okay. And so, Dr. Cutler, I was drawing your attention to Table 1. It indicated the duration was 3 hours and 3 minutes. Does that tell you anything at all? Or did that play a part in your analysis at all?
Well, interrogation time is one factor that we look at. Interrogation time is a risk factor for false confession. Generally, that's what we're looking for in these tactics, is whether the extent to which they are creating risk factors, or elevating the risk for false confession. We know from the research on interrogations and false confessions that that length of interrogation is a risk factor. Known cases of false confession typically involve longer interrogation times than other cases.
Moving on in your report, Table 2 is labeled Suspect Information and Personal Risk Factors, and your report indicates there are no risk factors indicated there, correct?
That's correct.
Is that common that you would find that the individual suspect would not present any personal risk factors and yet find that the interrogation as a whole was coercive?
Objection waiting.
Sustained.
Dr. Cutler, is it unusual that your findings in this case would be as they are, given the fact that there are no personal risk factors associated with Kelsie Thomas?
Objection waiting.
Objection overruled. You can answer.
It is fairly common that we have interrogations like this with suspects who do not possess known risk factors for false confession.
The next table listed in your report is entitled Physical Environment and Context, correct?
Yes.
And you have some factors listed there, one of which is her being questioned 8 continuous hours.
Waiting. Counsel testifying from the court.
Sustained. Go ahead and rephrase.
Thank you, Your Honor. Dr. Cutler, do you have your report there?
Yes.
You see in Table 3, labeled Physical Environment and Context.
Yes.
Were there any risk factors associated with Table 3 that you found important or relevant to your determination?
Yes, there were.
And can you tell the jury about those factors?
Yes, two of the items pertained to the length of the interrogation and the number of times that Ms. Thomas was interrogated within a relatively short span of time. The issue with interrogation length or amount of time is that over time our resistance gets worn down. Our ability to regulate our thoughts, behaviors, emotions becomes depleted over time. So when suspects go through longer periods of interrogation, their resistance, essentially their ability to defend themselves, continue to maintain their innocence, becomes diminished. Also, over time, where suspects continue to maintain their innocence and argue their innocence over and over, that activity itself also diminishes over time our ability to resist. So time and number of interrogations over a short period of time, which is related to time, can lead to fatigue and reduced resistance to the social influence that goes on in interrogation. The third pertains to the actual environment in which interrogations are conducted. The interrogation in this case, as usually happens, is that it's conducted in a small, relatively barren room where the suspect does not have immediate access to an advocate, social support, does not have the ability to communicate to anybody on the outside. The suspect is essentially isolated from other sources of support. Isolation is stressful for anybody. So over time, isolation adds stress and renders suspect more susceptible to social influence.
And just so the jury's clear, Dr. Cutler, did you find those factors present in this case?
Yes.
Specifically, what were those?
Well, the interrogation lasted. The interrogation that we coded lasted about 3 hours, but Ms. Thomas was continuously questioned for a much longer period of time. I believe it was about 8 hours through multiple interrogations, interviews and interrogations. And the interrogation that we coded was conducted in a relatively small, barren room, the likes of which can contribute to a sense of isolation and add to stress.
As part of your analysis, you sort of compiled a summary of the known tactics that were used in this case. Is that correct? And when you use the word tactic, what do you mean?
Tactics are essentially strategies or tools that interrogators are taught to use to basically bring about their goals, which is to get a confession and to get information that can help solve the crime. So investigators, when they go through training, learn basically a series or a toolbox of tactics that they can draw upon to encourage a suspect to confess and provide information.
Are these tactics necessarily good or bad?
There are some tactics that are trained, that interrogators are trained to use that I consider to be bad tactics because our research shows that they have a particularly high risk. They have a high risk for producing false confessions. Other tactics that are allowed, they vary in how coercive they are. But one of the things we look at is, among all the tactics, is how many were used, how many times were they used. So even where some of the worst tactics are not used, just the constant use of interrogation tactics can be very intense. And the sheer volume of it, the intensity of it, can increase the risk of false confession.
Is that an issue related to guilt presumptive interrogation?
The tactics that we examine and that we code are typically part of guilt presumptive interrogation.
Are police always interrogating guilty people when they employ these tactics?
They are not always interrogating guilty people.
Is that a problem?
To the extent that the police use tactics that encourage a suspect to confess, if they're always interrogating guilty people, then they're getting guilty people to confess and produce information that can help solve the crime. But when innocent people end up being interrogated, or they're thought that they could be guilty, some portion of innocent people will also confess, will falsely confess to the crime. There's a risk of false confession. So it can be a problem.
Are there different categories of interrogation tactics that you're familiar with?
Yes.
What is a rapport building tactic?
Rapport building tactic is a tactic that investigators use to try to establish rapport with a suspect, to act in a friendly way by expressing sympathy with the suspect or trying to in some way identify with the suspect. The idea behind it, interrogators are trained, is that people will naturally provide more information, disclose more information to those with whom they've established rapport.
Did law enforcement utilize these type of tactics in their interrogation of Kelsie Thomas in this case?
They did.
How often?
We counted 12 instances in which the investigators used rapport tactics, such as expressing sympathy with Ms. Thomas, basically acknowledging her emotional pain, and trading stories about the challenges associated with caring for children.
What is an evidence-based tactic?
Evidence-based tactics are where the investigator cites evidence as a means to put pressure on the suspect to confess. That, in general, that evidence could be real evidence that's been obtained in the case. It could be exaggerated evidence. It could be false evidence. But it can also be what we call bluffs about evidence. These are all part of evidence-based tactics. They're designed to convince the suspect that he or she that there's a lot of evidence against him or her, and that she won't have an easy time of convincing anybody that she's innocent.
And you may have just answered my next question, but which would have been, why do interviews use these type of tactics? What is their intention with those?
It's to remember the goal of this of a guilt presumptive interrogation is first to get the suspect to confess, and then after the suspect confesses, to get information from the suspect that can help solve the crime. So Evidence-based tactics serve the purpose of moving a suspect toward confession. Where there's a lot of evidence against the suspect, it's harder to continue to deny one's innocence.
How many times did you and your team document these evidence-based tactics being presented to Kelsie Thomas in the 3 hours that you reviewed?
We counted 132 times.
Is there a tactic known as evidence bait that you're familiar with?
Yes.
And can you tell the jury what evidence bait is?
Evidence bait, we sometimes call this an evidence bluff. The idea is that some of the evidence may not yet be in hand. And with this tactic, the investigator conveys that we're going to have evidence. It could be through, future testing. The evidence is going to show that you're guilty.
Was this particular tactic utilized against Kelsie Thomas?
It was.
And how many times did you document?
3 times.
And what is the effect of this particular tactic?
Well, there's some research on the effect of the bluff tactic on false confessions, and the research finds that bluffs of evidence can have the same effect of false evidence, that is, increasing the risk of false confession.
Based on your experience and research, is emotional provocation a tactic employed?
Yes.
And what can you tell the jury about emotional provocation?
Emotional provocation is it's basically designed to add stress to the interrogation, to make the suspect feel guilty about the act. It adds stress.
Was that employed in this case?
It was.
And what did your team document in that regard?
We found 12 instances of emotional provocation in the interrogation that we reviewed.
Moving on, Doctor, what are confrontational tactics and why are they risk factors for a false confession?
Confrontational tactics are an important part of guilt presumptive interrogation. The idea is to confront the suspect early on with being guilty by directly accusing the suspect of having committed the crime, by expressing certainty in the suspect's guilt, by leveraging authority. For example, we're a very experienced police officer. We've been doing this a long time. It involves derogating information provided by the suspect, such as accusing the suspect of lying, of being deceptive. And these sorts of confrontational tactics they're important, essential parts of putting pressure on the suspect to confess.
How many times did you and your team document confrontational tactics being used against Kelsie Thomas in the 3-hour interview you reviewed?
Uh, 153 times.
Moving on, Dr. Cutler, what are minimizing tactics and why are they risk factors for a false confession?
Whereas confrontation tactics put pressure on suspects to confess, minimizing tactics essentially make it easier for a suspect to confess. So they include things like appealing to the suspect's self-interest, trying to convince the suspect that he or she is, it's in his or her own best interest to confess, downplaying the seriousness of the crime, making it seem like it's not as heinous or problematic as it is, blaming other people for the crime, taking the blame off the suspect, and also providing justifications for the crime, such as you're not a bad person, you didn't do this deliberately, this was an accident, or a spur of the moment thing rather than a planned decision. Those are justifications. Our research on minimization tactics show that they also increase the risk of false confession. And the mechanism by which they do that, and actually interrogators are trained about this, is that minimization tactics, by offering essentially excuses for having committed the crime, it gets suspects to believe that they will be treated more leniently for confessing than for maintaining their innocence. So it's not explicitly saying that. I mean, they're not explicitly told that they will be treated more leniently, but these minimization tactics lead suspects to conclude that on their own.
Dr. Cutler, if in this case, ultimately Kelsie Thomas was presented by investigators with two options. One is she's a monster who would just kill her daughter premeditatedly, or she is the overburdened mom who just snapped. Is that a minimization tactic that was employed there?
It's in part a minimization tactic. It's also another tactic that we call alternative questions. The idea is to limit the suspect's degree of choices. So you notice being innocent wasn't one of those choices in that example. It was agreed to have committed the crime for this reason, which sounds awful, you're a monster, or agreed to this more excusable version of the crime, that it was an accident. That agreeing to the more minimized version of the crime leads people to think that they'll be treated more leniently for confessing. So it's that alternative question where this suspect is provided with two options, one sounding more excusable than the other. And the idea of providing excuses for having committed the crime is part of minimization.
How many times did you and your team document minimizing tactics being used against Kelsie Thomas in the 3-hour interview?
We found 65 instances.
Dr. Cutler, were there any other tactics that don't fit exactly into the compartments that you also documented that you believe were risk factors for false confession?
No, I think we've covered the the tactics that we reviewed, there's another component to our analysis, and that involves what we call contamination of confessions. It's not a tactic per se, but something that sometimes occurs in interrogations.
Okay, and we'll get to that here in a second, but in referring to your report, table 5,
I see. We did have a category of miscellaneous tactics.
and what tactics specifically utilized against Kelsie Thomas did you document in that regard?
Right. One of them, one of the tactics was aggressive questioning. This involved interrupting Ms. Thomas, asking leading questions or asking multiple questions at once. Some of this is part of training. Interrogators are trained to manage the suspect's denials. The idea is that the more frequently a suspect denies guilt, the harder it is for the suspect to walk that back and confess. So interrogators are trained to interrupt the suspect's denials. Some of them are also just not good interviewing practices. The other is that pertaining to the question of custody, at one point Ms. Thomas was asked if she was free to leave and didn't really get a straight answer from the investigators, but rather was told that it's really not a good idea. It's in her interest to stay and continue to answer questions.
Now, before I reminded you of that last table, Doctor, you had alluded to the next topic that I want to discuss with you, and that's confession contamination. Can you define what confession contamination is for the jury?
Yes. Recall that I mentioned that the overarching goal of interrogation is to get information from a suspect that can be used to help solve the crime. The idea is that a guilty suspect will have information that only the guilty suspect knows, that an innocent suspect wouldn't have that information. So the process involves getting the confession and then following that, getting information from the suspect. What sometimes happens, and we know this from documented false confession cases, is that investigators inadvertently or advertently provide information to the suspect during the course of interrogation about details of the crime. And the suspect can basically learn those details and adopt them so that an innocent suspect can appear to be quite knowledgeable about the crime and can provide details, not because the innocent suspect was the criminal and was present, but because the innocent suspect had learned those details in the course of interrogation. We call that contamination of the confession by the interrogator. And again, many times it's just inadvertent. The investigator doesn't realize that's what's happening. But it can make false confessions appear compelling because it makes it seem that the suspect has guilty knowledge. And it also makes it difficult to evaluate the confession because if you don't know whether the suspect is innocent or guilty, which is generally the case, you don't know whether the details provided by the suspect are known from personal experience, from being a perpetrator, or have been learned during the course of interrogation.
Was, in your opinion, confession contamination a factor in the interrogation of Kelsie Thomas?
Yes.
Can you explain that to the jury?
Well, what we do in our analysis is we do our best to track what information came out when in the course of the interrogations. Who said what first? Was it the suspect who, on his or her own, came out and provided unique details that weren't known, or was it the interrogators that suggested ideas and provided information? And we found in this case that the ideas were largely provided by the investigators in the case rather than by Ms. Thomas.
Can you provide the jury with some explicit examples of that happening in Kelsie Thomas's interrogation?
Yes. These are some of the points that we documented. Were first mentioned by the investigators. At one point, one of the investigators said, "What happens when you come back in and look at her? She's still in the same spot, wasn't she? Is that when you knew that maybe you had pushed too hard?" It was also the investigators who first suggested that Chloe died while lying in bed. Ms. Thomas was pushing down on her. After Ms. Thomas agreed, the investigators essentially rebuked her and pointed out that the ligature markings were not consistent with that version of events. They repeatedly told Ms. Thomas that her confession must match the medical evidence and told her exactly what the medical evidence showed. One of the investigators suggested that Chloe's shirt was pushed upwards and might have caused the marks around Chloe's neck. Ms. Thomas responded that she might have. She was so angry when I was pushing her shirt, it might have gone up. The investigators suggested that the ligature markings were made by something being placed around Chloe's neck and force being applied in an upward direction. Let's see. There was another point where the investigators were asking Ms. Thomas about her thought processes and whether she experienced remorse. It's another form of contamination, but we find that in known cases of false confession, it's not uncommon to have expressions of remorse and apologies. There was a study published in one of our forensic psychology journals where the investigators analyzed, it was about 20 known cases of false confessions and found that about a quarter of them involved apologies by the suspect. So encouraging the suspect to apologize or asking about remorse is another form of contamination.
And on that topic, Doctor, would that also include apology letters?
That's a form of an apology, yes.
Were you aware that Kelsie Thomas wrote an apology letter in this case?
Yes.
And that would be consistent with, again, your statement that that was...
Staying.
Would that be consistent with contamination of the confession?
Yes, it could be.
That was in fact suggested by one of the investigators for her to do that, correct?
Yes.
With regard to the confession that Kelsie Thomas ultimately provided to law enforcement, did you note any inconsistencies in that confession?
Objection, Your Honor, prior motion.
Sustained.
Dr. Cutler, are inconsistent statements in a person's confession known risk factors for a false confession?
No, I wouldn't say that inconsistent statements are known risk factors per se, but relevant to the question of inconsistent statements is whether the suspect did in fact provide unique information or guilty knowledge that could later be corroborated.
In your review, did you discover any of that unique
Objection, Your
information?
Honor, prior motion. Also
Sustained.
conclusion.
In your review, did you make note of any unique details Kelsie Thomas provided about the death of Cloe Chandler?
Objection, Your Honor, prior motion.
Sustained.
Dr. Cutler, were you able to quantify the total number of interrogation tactics used in the 3-hour interview of Kelsie Thomas?
Yes.
And what total number did you come to?
374.
And that was only in the 3-hour interrogation that you reviewed, correct?
That's correct.
What does your research and training tell you about the total number and the total amount of different interrogation tactics that took place during Kelsie Thomas's interrogation?
This was a highly intense interrogation. We've reviewed many interrogations, not just for cases, but for our research. And this is among the most intense interrogation that we have seen.
Would you characterize this interrogation as coercive?
I would.
And I believe you stated earlier, just so the jury's clear, this type of interrogation would encourage both an innocent person and a guilty person to confess. Is that correct?
Yes.
And that is your expert opinion, correct?
Yes.
And the basis of your expert opinion is?
My understanding of social psychology, of forensic psychological research on interrogations, confession, and my own experience.
All of those things you applied to your analysis in this case?
Yes.
I have nothing further, Your Honor.
Cross.
Good afternoon, sir.
Good afternoon.
Sorry we don't have better weather coming down from Canada. Now, as far as your background, you've been a professor since 1987, correct?
That's correct.
And you noted a couple different studies. I think you noted specifically Casson and Leo being kind of seminal figures in your area of research, correct?
That's correct.
And I just want to talk to you a bit about those folks. From what I understand, Casson actually conducted the first lab experiment on false confessions in 1996. Is that correct?
I don't know if it was the first. It was certainly one of the earlier ones and very prominent.
I think it was labeled false confessions, just simply.
I don't recall.
And at least as to that study, are you fairly familiar with it, given it being one of the first major works?
I'm familiar with his work in general. If I knew more about what you were talking about, I'd be able to answer the question. I'm not sure exactly which publication you're referring to.
And it would be, just for your reference, the computer case with the tab that would shut down matters.
I'm familiar with that, yes.
I believe he used a pool of 75 college students, correct?
That sounds right.
They were all told to type on a computer, at least for this experiment.
Yes.
And then, after about a minute, the researchers deliberately crashed all the computers.
That's correct.
Now, prior to them getting on these computers, they were told that if they touched the Alt key, that's what would crash the computers, correct?
Yes.
But in truth, the researchers just did it on their own.
Yes.
Then the researchers interrogated the students using different techniques, correct?
Yes.
And some admitted to having clicked the tab key or Alt key, which caused the crash, correct?
That's correct.
Now, this is one of the lab experiments you were somewhat referring to in your earlier questioning, correct?
That's a common kind of methodology that's used in laboratory research on false confessions.
And though things have come further, and we'll talk about, I think, a 2016 study of yourself, but at least at that time, Casson admitted that this experiment involved negligence and not deliberate criminal intent, correct?
Correct.
And then there was admittedly only minor consequences to admitting to liability in the situation.
That's correct as well.
Going to Richard Leo, I believe you may have mentioned he relied on publication to some extent that he published in 2008 or 9.
I was referring to a book that he authored. I think it was 2008. He has a great deal of other research that I've read, but that specific publication was a book. Yes.
And one of those studies that may or may not have been in the book was a 1998 study called The Consequences of False Confessions, correct?
Yes.
That case, I believe they had a sample of 60 cases involving a confession.
I don't recall it. It sounds right, but I don't recall that level of detail.
At least in terms of ballpark, let's go with that. Does that sound about right? Maybe it's 50 or 80 or 100 even, but about that area, correct?
Yes.
And in that study, I believe they determined falsity of confessions by comparing the defendant's statements to whether or not there was corroborating evidence.
Right.
They did not interview the witnesses in the cases to weigh the defendant's claim of a false confession.
No, I don't think they did that.
And they did not use court determinations of innocence or guilt to weigh the confession.
No, I don't think they did that either.
Now, some of the confessions, at least from what I could tell in the study, involved the actual use of force to obtain a confession, correct?
That I don't recall.
That is sometimes a tactic that has popped up occasionally.
The use of force?
Yes.
It is rare since the 1930s, but it has happened, yes.
I think Miranda v. Arizona, that was probably a bigger one involving beatings and confessions, correct?
I honestly don't know.
But it's a tactic that did pop up in the 70s and 80s as well, correct?
Yes.
Now, as far as this study, Leo admitted that he could not determine the frequency of false confessions in the real world, correct?
Yes, that's correct.
And at least as to data, there isn't any data giving a statistical likelihood of a false confession in an individual case, at least as of yet.
No, we know of instances, but the incidence rate or base rate of false confessions would be very difficult to know, and we don't know that.
Essentially, we have to wait till we can get into somebody's brain, huh?
Be nice if we could get that kind of data, but it's very hard to know.
Now, going to the 2016 lab study that you and your students conducted, are you familiar with what I'm referencing?
Would that be the Loney and Cutler?
I believe so. It involved the pressure techniques with the theft accusation.
Yes.
As far as and correct me if I'm wrong with this, you had pressure techniques that were used on eyewitnesses to give false accusations.
That's correct.
And you found more studies and students in the study accused another student of theft, sorry for the tongue twisting, in high pressure conditions.
That's correct.
Now, did these students have any belief that there would be significant consequences criminally for their accusation?
I don't think they would have believed that there would be criminal consequences. But we tried in simulation research, we tried to create the sense that there are real consequences behind what's done. Obviously not to the level of a criminal case. We have ethical constraints that govern what we can do. And we tried to create a belief that there are consequences.
And just going through those ethical considerations, it may be common sense or whatnot. You're not allowed to make somebody genuinely believe they're accused of murder and interrogate them, correct?
I don't think our research ethics boards would allow us to do something like that. It's not a good idea.
Now, going to this case, you reviewed this case for risk factors that could increase the likelihood of a false confession, correct?
Correct.
And I believe you noted you reviewed a 3-hour and 3-minute videotaped questioning, correct?
Yes.
As well as a handwritten statement by Ms. Thomas,
Yes.
and maybe a report as to the prior discussions or questioning earlier that day.
Yes.
That was all on, the questioning was all on July 26, 2018. Does that sound about right?
It sounds about right, yes.
Were you given any videotapes as to a questioning that took place on July 24th, 2018?
So that would be after the...
Before.
I reviewed one other interview/interrogation. I'm not exactly sure what date it occurred.
I guess I differentiate. Was it conducted by these same two individuals of the 3-hour interrogation?
Yes.
As far as any recorded jail phone calls, did you receive any of those to review?
No.
Did you review any calls involving the defendant speaking to her husband?
No.
Did you review any calls where she apologized to him, saying it was an accident that Chloe was hurt?
I did not.
Did you review a video of Kelsie Thomas giving the police a walkthrough and explaining how Miss Cloe Chandler died?
I did not.
Did you review a video of Kelsie Thomas speaking with an officer at the hospital on the day that Chloe died?
I did not.
And I know sometimes this takes place, it depends on the expert, but did you interview Miss Kelsie Thomas?
No, that's not something I would do.
You did not assess her mental capacity?
No.
And you did not evaluate her, though I think you are a psychologist, correct?
Well, I'm a social psychologist. The kinds of evaluations that you're referring to would be conducted typically by licensed clinical psychologists who are doing an assessment of her in particular. That's not something that I would do.
Part of my ignorance on that. They would, I suppose that type of psychologist would be able to diagnose her if she has any mental capacity issues or mental disabilities or disorders, correct?
Correct.
And that was not done here, at least by yourself, given your different professional role or one of your students with their abilities.
Well, that's correct, and that's why I indicated in the report that we knew of no personal risk factors in the case.
At least as far as personal risk factors, the literature goes through some, correct?
Yes.
That can be even stuff that's not a disorder, like sleep deprivation, correct?
Yes.
At least food deprivation has been known to be a tactic in the past.
It's been known to be a tactic, and sometimes it just happens without any deliberate action on the part of the investigators when people don't eat.
Limitation on bathroom breaks, for instance, that would be another risk factor.
Yes, discomfort in general.
if the suspect is under drug or alcohol abuse or drug or alcohol influence.
Yes.
And then if they have a mental disability or personality disorder, that's also a risk factor.
Yes.
Intelligence can sometimes be an issue,
It can be, yes.
but at least given that you do not interview Ms. Thomas herself or assess her, you don't know how smart she is.
Well, that's correct.
You don't know if she suffers from any memory issues or lack thereof.
That's correct.
You don't know if she's highly sophisticated or less in terms of maybe the legal system or questioning itself.
No, the only thing we knew was from what we observed, and as I indicated in the report, we didn't know of any personal risk factors.
And once again, I think this was clear, but you're not giving your opinion as to the accuracy itself of the confession, correct?
Yes, that's correct.
And in truth, you actually do not do that in any case, correct?
That's correct.
Now, are you familiar with some of the writings of Professor Paul Castle?
I may have read something of his in the past. I'm familiar with, I guess, his work by reputation, so I know a little bit about it, but I don't recall if I've read anything by him.
And the only things I was really getting at, let's go to the Leo study, for instance. And if you don't know, feel free to let me know, but at least Castle noted that there are 60 cases that were reviewed for that study, but in the same time frame, 386,000 interrogations have taken place in murder cases. Does that sound about correct?
I haven't read it, but it certainly sounds correct.
And I suppose what I'm getting at, there's no known error rate for, say, when you assess whether a confession could have been yielded falsely or anything like that. You can't tell, at least with your methodology, when you essentially get it wrong. And by you, I don't mean you yourself, I just mean researchers in general.
Sure. We can estimate false confessions in our laboratory studies because we know that they're false, but they also don't resemble what happens in high-stakes crimes. And in actual cases, such as in observational studies of false, of wrongful convictions or archival studies, we really can't use that information to come up with a base rate or an incidence rate of false confessions. We just don't know what it is.
And for instance, the Casson studies or the Leo studies, they don't, or even your own, they didn't involve accusations of major crimes such as murder, correct?
Well, in our experiments, we certainly don't. In some of Leo has authored research on where he's observed actual interrogations and conducted archival analysis of known cases of false confession, and many of those involved very serious crimes such as murder.
But at least the lab studies, due to the ethical constraints that you mentioned earlier, those don't involve like a horrible major crime, correct?
That's correct.
And at least as to proven false confession cases, I think Leo actually noted 4 categories. Are you familiar with those categories?
I'm sorry, 4 categories of, I didn't get the first part.
I may have spoken too quickly. At least as to proven false confession cases, Leo identified 4 of these in terms of categories in his work. Are you familiar with those categories?
If you're referring to voluntary false confessions, persuaded false confessions, if that's the distinctions you're referring to, then I'm familiar with that.
And yes, it is. As far as the way he breaks it down, he notes there are false confessions where no crime occurred, and he reviews those, correct?
Yes.
And then some also involve a false confession where the defendant simply physically could not have committed the crime.
Okay, this is a different distinction than I was thinking of, but yes.
But you're still familiar with this one, correct?
Yes, I've read this at some point, yes.
Appreciate it. As far as, there's also false confessions where a real perpetrator eventually confesses, correct?
Yes.
And then there's finally the fourth category where a DNA analysis establishes that the confessor is innocent.
Right.
And he also identifies different types of false confession. One being notoriety theory, where a person confesses for purposes of notoriety, correct?
Yes.
Compliance theory, it sounds like that's somewhat what you're discussing here, where a person may confess to escape the pressures of interrogation for some reason.
Correct.
And finally, there's the internalized false confession, where the police implant the memory into the confessor's mind to some extent.
That's generally the case, yes.
To be honest, the last one sounds a little bit like conception to some extent, where the suspect with no prior memory takes on what the police are saying. Is that maybe a little bit ridiculous in comparison? Is that essentially what that type of style is getting at?
I'm not familiar with that.
It's a movie.
A movie? No, I haven't seen it. But in an internalized false confession, which are less common than compliant or persuaded false confession, the suspect is persuaded to falsely confess and then comes to doubt his or her own memory and comes to believe that he or she actually committed the crime. So there are some instances in which that happened.
I was just curious, were there any documented cases of a false confession where the person began to believe in the confession, where they later confessed or made statements aligning with the confession to close family members?
May I have the question again?
Yes. Were there any instances where someone under this style of false confession, where they believed it themselves, later on, as opposed to retracting the confession, continued to essentially confess or speak in line with the confession to close family members?
I don't know of cases in which the false confession was carried through to close family members, but there have been cases where the false confession was made under different circumstances, yes.
In those circumstances, I'm guessing you're referring to the interrogation itself, where the false confession was given at the interrogation.
No, I was thinking of situations in which people have falsely confessed to crimes during interrogation and then later again falsely confessed to parole boards as a means of trying to get parole for the crime for which they were incarcerated.
Kind of self-interest, they're accepting it, so the parole board thinks they're accepting guilt.
Yes, exactly.
Now, as far as Kelsie Thomas, you do not know personally, you've never met her personally, correct?
That's correct.
Even though you reviewed 3 hours and 3 minutes of tape, you don't know what she was actually thinking throughout.
That's correct.
You don't know what was really important to her during these statements?
That's correct.
At least as to an interview, you never assessed whether she herself reported feeling undue pressure?
That's correct.
You don't know, beyond maybe assessments of body language, what her actual feelings and emotions were?
That's correct.
And finally, you don't know what exactly motivated her personally to say what she said?
That's correct as well.
Now, you've noted that custody can be a possible factor in yielding a confession, correct?
Yes.
And that's just because, like you said, a small room without access to emotional support, family members, things like that, can isolate a person and wear them down.
Yes, that form of isolation can contribute to the stress experienced by the suspect.
And obviously, if they're not in custody, that alleviates that factor to some extent, correct?
Such as if they're interrogated in a different environment. Yes, and that happens sometimes too.
Sometimes at their own home.
Yes.
Now, if someone's free to leave, and they in fact do leave and come and go, that would be a factor weighing against custody, correct?
The critical question would be whether somebody perceives that one is free to leave. One could be told that one's free to leave, yet feel the pressure to stay. We call that psychological detention. We know of instances where people have been told they're free to leave, yet felt the pressure to stay and continue.
Kind of like somebody offering some snacks or something on a visit, but you don't really feel actually like they're really wanting you to stay, kind of thing, and so you don't ask for anything.
Well, yeah, generally one may read into the situation something other than what one is being told.
But if somebody actually takes up the questioner on that request to leave or option to leave, they actually do in fact do so, that would indicate that they are, at least to some extent, accepting that they can leave, correct?
Yes.
Same thing with water. If you're told you may have water if you want it, the fact that you ask for it shows that you're accepting that that is a genuine offer of water, correct?
Yes.
Now, as far as implied promises or threats, there's a difference between implied and express promises, correct?
Yes.
An example of an express promise, or threat as well, if you touch the stove, I'll hit you.
Yes.
Or if you do your chores, I'll give you $10.
Yes, that would be explicit.
Now, as far as implied threats, though, they require the person who hears them to interpret them as a threat, correct?
Yes.
Or an implied benefit. The person has to understand that implication, correct?
That's correct.
So, as far as the person who actually hears them, if they don't recognize the implied promise or the implied threat, it doesn't have its intended effect, correct?
That's correct.
And you recognize that the jury has listened to other matters, maybe beyond what you've assessed for this case, correct?
Yes.
As far as this case, you noted that the social influence of a small room can factor into a false confession. Now, social influence, is there any way for you to mimic the social factor of essentially when you admit to an awful crime, community or family turning against you?
I'm not sure I understand the question.
Well, essentially, is there any way to mimic in your experiments for someone to admit to child murder, essentially, and what effect that can have in terms of the social stigma of having admitted to that?
Not directly in our experiments, no.
And that would be a significant factor weighing on anybody making statements, whether saying they didn't or did commit such a crime, correct?
That their perceived reputation with their family and community would be a significant factor?
Yes, sir. That's exactly
I
right.
would think so.
Now, have you yourself ever done an interrogation of a criminal suspect?
Not of a criminal suspect.
Pass the witness, Your Honor.
Redirect.
Thank you, Your Honor. Dr. Cutler, earlier on in your cross-examination, you were asked about the materials that you reviewed, and other than the 3-hour interview, you also recalled reviewing one other interview of Kelsie Thomas, correct?
Correct.
And you recall, was she wearing the same clothes in both interview or different clothes in both interviews?
She was wearing different clothing.
Now, you were also asked about jail phone calls, and you didn't review any jail phone calls, did you?
I did not.
Now, this idea of sort of false apologies, people who falsely confess and they also apologize for their alleged crimes, that's a dynamic you've observed in your research, correct?
Yes,
We have documented cases that tell us that that happens, correct?
that's correct.
And in the example you used, I believe you indicated there's a documented case of somebody who falsely confessed. They presumably went to prison because they were on parole, and then they continued with that false confession for the purpose of getting favorable treatment from the parole board, and then later on, I assume, it was found out that all of that was based on a false confession?
That has happened, yes.
Okay. Is there any time length where the suspect's apology is going to wear off? And if I could rephrase that, if the state were to assert that, well, Kelsie Thomas was being interrogated for this time, but that doesn't explain why she would have made this jail call after she was interrogated. Can you address that?
Objection. Proper question calls for conclusion.
Objection overruled. Witness can answer.
The underlying, in a case of false confession, again, I'm not saying this is a case of false confession, I wouldn't know that, but the suspect comes to believe that he or she will be treated more leniently by confessing, and along with confessing to what seems like a lesser version of a crime, there could be apologies. So as long as the suspect continues to believe that by acting remorsefully and apologizing, that will lead to lesser consequences, a lesser sentence, then we would expect the suspect to maintain that same position, if that's what it's serving.
Now that you've been made aware that Kelsie Thomas made some jail phone calls after her confession, does that impact your ultimate opinion at all?
Objection. Speculation lack of foundation.
Objection overruled. Witness may answer.
Well, my opinions were about the risk factors associated with false confession in the interrogation, and not about whether the confession was accurate or not. So, no, it doesn't affect my opinions about the risk factors in the interrogation.
You had mentioned another interview in which Kelsie Thomas was dressed in a different manner. Did you note risk factors in that, in your observations? Did you notice risk factors present in that interview as well?
Yes, there were accusatory tactics used in that interview as well, but I didn't document it.
Right. Now, you were also asked several questions about how well you knew Kelsie Thomas, things of that nature, correct?
Yes.
The fact is that part of your overall analysis, you're actually looking at the suspect's demeanor and her behaviors that you observed, correct?
Yes.
So all those were factors that you took into account.
Prior motion.
Sustained.
The state has opened the door with questions related to her mental capacity, her appearance, and all those things on cross-examination.
Court's heard that there were no risk factors noted, no personal risk factors noted, and so I don't think there needs to be any further testimony regarding that.
Now, referring back to your direct testimony, Dr. Cutler, if I understand correctly, a tactic doesn't necessarily mean that it's a risk factor, but a combination of several factors become more risky, essentially. Is that correct?
Yes.
So you might have a tactic that on its own doesn't produce any risk factor for false confessions, but in totality, that risk would be heightened. Is that correct?
That's correct.
And what was the total number of risk factors you documented in just the 3-hour interview that you reviewed?
Well, the total number of tactics was 374.
You were asked about whether or not police made any explicit threats during the interrogation of Kelsie Thomas, correct?
Objection. Mischaracterized the question. For testimony and questions.
Objection overruled. The witness may answer.
May I have the question again?
Sure. You were asked during cross-examination whether or not investigators made any explicit threats to Kelsie Thomas, and you're asked to distinguish between an explicit and an implicit threat. Do you recall that testimony?
I recall being asked to distinguish between explicit and implicit threats, but I don't recall being asked whether explicit threats were used.
Okay, fair enough. Would it be accurate to say that explicit threats don't exist a whole lot often in interrogation?
No, I wouldn't characterize it that way.
How would you characterize it?
Trainers of interrogation teach interrogators that they shouldn't make threats involving real consequences, such as you will be treated more harshly if you maintain your innocence. That's what's considered a real consequence, but it's okay to make other kinds of threats for what they consider less real or less tangible consequences, such as people will think less highly of you. Your reputation will be ruined if you continue to maintain your innocence. So, these seem to me to have consequences, but that's how trainers teach it. So it's not uncommon to have, for interrogators to mention threats involving other sorts of consequences, such as reputational issues.
Okay. Now, and I think finally you were asked about the experiments that you've participated in, the research you've participated in, and the methodology behind that. And it was pointed out that a lot of those things just don't happen in real life, correct?
Yes, that they're not realistic, heinous crimes. They're relatively innocuous laboratory settings.
But at the same time, the actual case law that you're familiar with as it pertains to the issues of interrogations and false confessions, those are real-life case studies involving real criminal cases, ultimately proven to be innocent through DNA exoneration, other exculpatory evidence being come to light at a later date, correct?
We rely on different kinds of methodologies. The laboratory experiments, as was mentioned, may not seem realistic, but they provide unique information because we know in laboratory studies whether confessions are true or false. But we also rely on observational studies of actual interrogations where we may not know whether the confessions are true or false, but we're learning about what happens. There's archival studies, that is, studies of cases that have already been resolved and we can understand them in records. There are surveys of police officers and defendants who have confessed truly or falsely. So we rely on a variety of methodologies, each one with its unique strengths and weaknesses when trying to understand interrogations and false confessions.
And so would it be fair to say that the basis of your opinion, you are relying not only on the empirical research that you participated in and testified about, but you're also relying on case methodology, things that actually happened in real life, studies that were conducted that you are aware actually happened, correct?
Objection, waiting, asked and answered.
Sustained.
Dr. Cutler, is your opinion based solely on your empirical research?
No.
What else is your opinion based on?
Objection, asked and answered.
If there's no rule, the witness may answer.
I rely on a broad base of literature, social psychology generally, forensic psychology, specific research on interrogations and confessions, and that includes laboratory experiments, studies of actual crimes, observational studies of interrogations, archival studies or studies of records from crimes, survey research, and also the interrogation training literature, which I mentioned earlier. I do my best to rely on the variety of sources of knowledge that are available to us.
I have no further questions, Your Honor. Thank you, Doctor.
Reed Cross?
Nothing for this witness, Your Honor.
You may step down. May this witness be excused?
You may, Your Honor.
You may also be excused and leave the courtroom if you choose to do so.
Thank you.
Members of the jury, we're going to take a mid-afternoon break. Please remember all the prior admonitions. Keep it in mind. Don't talk to anyone about this case. Pay no attention to any media accounts.